So, welcome everyone to the People's Pardon or Jury Nullification. This training is the first training that Freedom Trainers has done focused on this specific tactic. We could say a little bit more about why we've been thinking it's a useful tactic, but it's one that has a long history. We'll learn more about it. It's one that seems relevant for these times, particularly as we're seeing illegal, unconstitutional, excessive behavior on parts of Border Patrol, ICE, name your favorite federal agent that's overreaching in these times. But there's an abundant number of reasons that people have used jury nullification for abolitionists against the system. So we're going to get right into it, sort of walk through. It'll be a lot of slides. We will share all the slides afterwards. Neither Latanya nor I are necessarily experts on this. There are some of you actually on this call who know more about it, and that's wonderful. The thing that we want to model here is a kind of training that you can uh, do for your own crew. You can take these slides, adapt them, and use them right with your people. Um, just as a way to kind of acknowledge the room, just want to welcome folks. And if you want to just like share your name, and maybe just like a time when you stood up for someone else. So a lot of jury nullification is about standing up for other people. It's not just about our own selves. It's about being in solidarity and connection with other people, and just to remind ourselves about that. So if folks want to just throw that in the chat while we continue on with a couple of different pieces. Latanya.
Yes. So my name is Latanya. I'm trying to put a little note to Adam in that note. But my name is Latanya Lane. I use she, her pronouns. I am a senior trainer at an organization called People's Action, and I'm here as a trainer with Freedom Trainers. And this is the quick note that I was talking about earlier, where if you're currently on a jury, this presentation is not for you. And that's because courts have ruled that speaking with active jurors about jury nullification or about any outside information related to the law, so it's not just about jury nullification, but a couple of things, it can actually be grounds for removal, and in some places it's considered illegal. So we don't want to give any appearance of tampering with a court proceeding. So if you're actively on a jury, this is the time to kind of log off, say thanks. After I'm done with my role as a juror, I will come and learn about this. But right now, as a juror, is not the time to learn this.
So it's like do a scenario. So we're just gonna like imagine a particular scenario. This happens to be based on a true story. So some of you have heard of Sandwich Guy. So this was, as many of you know, in Washington, D.C., there's a gentleman who uh, was irritated that 1,500 National Guards had been deployed into Washington, D.C., and were setting up random checkpoints, were just being aggressive, abusive, and unnecessary. So the militarization of their streets. And so he approaches a federal agent, shouts, "You fucking fascist," shouts some other things. "Why are you here? I don't want you in the city." And then he throws a Subway sandwich, probably the most famous Subway sandwich anywhere in the country, in the globe. So let's just imagine in this scenario that you've been put on a grand jury. So not all crimes necessarily need grand juries. But in this case, the Department of Justice decided that they wanted to try him and try him as a felony charge. And so, in order to make sure that you're not sort of doing frivolous cases or so forth, there's a process called a grand jury. That process is different than like a criminal court, where you a criminal trial where you like most TV shows are built around those. This instead is a grand jury where they're trying to decide whether or not there's enough evidence to warrant an actual criminal trial. So typically they're very biased because the prosecution gets to make their case on their own without a kind of a role of defense. They're just trying to say, is there enough evidence to put this together? So you get to practice your own independent judgment to just decide what justice looks like. So the prosecutor starts in and says, look, you're in this grand jury to review evidence presented us to decide whether there's enough reason to formally charge someone with a serious crime. This is a direct quote from the prosecutor. It says, "We all may have views about the federal law enforcement presence in DC. That's not what this case is about. There's no defense here because you're not going to determine guilt or innocence, only whether the case should even go to trial."
Court documents and video show what prosecutors say happened Sunday night near 14th and U Street. They allege Dunn verbally confronted federal officers, then threw his Subway sandwich at one of them at close range.
In retrospect, he's going to say, hey, why did I do that? But at the time, mentally, he's like, hey, this is my city. Don't want you here.
Police arrested Dunn, and according to court records, he admitted, quote, I did it. I threw the sandwich.
It's tragic.
He appeared in D.C. Superior Court Monday where a judge released him. But on Wednesday, federal prosecutors issued a new arrest warrant charging him with felony assault in federal court. Now, inside the courtroom, Dunn's attorney said he tried to turn himself in, but received no response from the DOJ. She claims 20 officers later came to his home to arrest him. The attorney also revealed Dunn served in the U.S. Air Force, which was a fact prosecutors didn't appear to know, and that he had been working for the DOJ.
Okay, so you saw the video, says the prosecutor. He attacked an officer, he ran, and he admitted it. So you just can't go throwing stuff at people when you're mad. You can't do it to your neighbor, and you can't do it to law enforcement. So the prosecutor argues this is an aggravated assault, not just a misdemeanor, but it's a felony for assaulting, resisting, and impeding an officer under U.S. Title 18 under the United States Code. Okay, so the prosecutor says indict, but you don't necessarily, maybe you don't feel good about it. So throw in the chat, like, how might you vote against indictment? What's an argument or a thing that you might say about some different reasons that you might oppose? Why might you say that this shouldn't go to trial? Go ahead and kind of throw some of those into the chat. This is a chance just for you to think through what are some of the different reasons that you might say in terms of it. Just reading one that's already there is it's nonsense. These are overblown. It's trivial assault. It's not felony worthy. It's not aggravated. A sandwich isn't aggravated. Onions are not aggravated assault, et cetera, et cetera. So there's a lot of possible reasons that one could argue. So you can argue, was the law that was broken just and justly applied in this case? And these are not just for this moment, but for any moment. Is the law broken constitutional? A juror doesn't have to believe that a law that's being invoked at a particular time is being applied in a constitutional manner. Are there other factors that make strict enforcement of the law that's unjust? It's unreasonable. They were being reasonable at the time, any number of arguments. Was anyone actually being harmed? Would the punishment itself fit the crime? Or you're just not persuaded. You don't have to be persuaded on any of these grounds. So all of these and the things that folks are chatting in are all different examples of reasons that one might say, I'm not actually going to vote to indict. So in this case, you vote not to indict. But grand juries don't need, typically, unanimous decisions. They only need, in most places, a majority of jurors to vote yes. Again, that's a difference between them and many criminal courtrooms. So the prosecutor decides to make the jurors stay late. They pressure everyone to indict. They threaten jurors. These are all some legally dubious strategies that do happen. So what actually happens? So let's just follow the.
And here's the kicker. Today we learned that federal prosecutors were not able to convince a grand jury to charge him with a felony. A group of his peers simply refused to buy the government's ginned up case. And to be clear, in normal times, it is extraordinarily rare for a grand jury to refuse to approve an indictment. The deck is heavily stacked towards the prosecutors in these situations. There's the old cliche, right? You could get a grand jury to indict a ham sandwich. And yet, the U.S. Attorney's Office for D.C. could not get a grand jury to indict a guy for throwing the sandwich. This isn't an isolated incident. Earlier this week, we learned that same U.S. Attorney, Jeanine Pirro, last seen on Fox's The Five, that her office similarly failed to get a felony indictment against a woman who's alleged to have tried to block ICE from detaining someone. Not one, not two, but 3 grand juries refused to sign off on felony charges in that case. Eventually, Pirro just gave up. Charged her with a misdemeanor instead. These are just some of the latest examples of grand juries, even prosecutors themselves, judges refusing to go along with Donald Trump's weaponization of the Department of Justice.
So that's jury nullification. That's the heartbeat of it. So it's when a jury believes that prosecutors may have proved the technical elements of a case, that maybe the person actually did that behavior. But for whatever reason, the jury decides to have a moral objection or a technical objection or some other kind of objection and decides to choose not guilty or not indicting. So in this case, I'm tracking this particular story of the sandwich guy. So prosecutors file a grand jury under felony charges. Sometimes grand juries are necessary. That changes a little bit from court to court system. But in this case, the grand jury said no to the indictment. And then, in a rare move, the prosecutors decided they're going to just file a lesser misdemeanor charge, which didn't require a grand jury. So instead, this goes before a criminal jury. So criminal juries are a little bit different. They're more like if you see any TV show, that's almost always a criminal jury case. Amazingly, shockingly, you've been put on his criminal jury. So this is the place where they actually determine guilt or innocence. So it's traditional courtroom. Again, like I said, like you might see on TV. So each you are all in different locations, and so your particular state law may be a little bit varying. But typically, criminal juries need a unanimous agreement in order to convict someone, in order to say that they're guilty. So one person can hang a jury is the phrase. That is, there's no conviction. And if a jury all decides, makes a decision together, they can find someone not guilty. So again, prosecutor gets to make their case first. This is not a case about someone with strong opinions. It's about an individual who crossed the line. Direct quote. You'll hear the aggrieved officer smelling the onions and the mustard. This was not quite a direct quote, but this is about said. You just cannot have people going around attacking federal officials. The defense then gets to make their argument. The defense, in this case, rebuts largely saying, look, a foot long from Subway just could not and certainly did not inflict any body harm. Throwing a sandwich is not a forcible offense. This whole case is vindictive and selective prosecution. They're targeting him because of speech, not actually because of harm that happened to him. So once again, you face the question, how might you internally decide to vote against a conviction anyway? So you gave some different reasons. You might take a shot here at sharpening any of those. Again, you can put those in the chat. And again, the internal practice here is thinking through your own position. How do you hold that position inside of yourself? Because there may be others who then put pressure on you. How you articulate that to other people may be a different thing. So those are two separate things we're tracking here. One, how do I individually hold my own to say, no, I don't think he's guilty for this particular behavior. I'm not willing to convict him. The second is then how might you articulate that? And we'll talk a little bit more about that a little bit later. Again, people are putting in different examples of what they would say. Throwing the sandwich was morally good. Harm wasn't caused. There's no need for a legal remedy. Again, these are different ways of articulating how we might handle this. And again, in this case, in reality, the jury acquitted them, found them not guilty. And so again, Sandwich Guy was released. And again, we get to affirm this is another act of jury nullification. It's a place where juries are used to track when the government is in the wrong, and they're used to course correct. And so in this system, we have a legal remedy to correct when the court system, when the Department of Justice has gone astray and awry. And so that is your right as a juror to stand up for what you believe to be right, to use your analysis, your conscience, your morals. And so, yes, so this is a high profile case of this happening in real time. It has some unique properties. I just want to march it. It's not common to have a failed grand jury and then a failed criminal jury. And as Latanya is about to explain, there is in fact a long history of jury nullification in the United States.
I love the math that is happening in the chat. And also, as Daniel just said, there's this long history of jury nullification in the United States. I know some folks came into this training curious about whether this is legal. The amount of precedent for jury nullification hopefully like warms your heart because this is something we've been doing for quite some time. So as far back as 1735, when we were not even, the Declaration of Independence had not yet been signed. There was a guy named John Peter Zenger. He was frustrated with the colonial governor. He was printing some papers that was criticizing the colonial governor, and he was charged with libel. The jury found him not guilty. Even though it was clear that Zenger had printed the material, the jury refused to convict him, which was one of the earliest establishments of freedom of the press principles. And it also showed how jurors play a really important role in defying unjust laws. Another example we have are during the Fugitive Slave Act, which was an act that was around up until about, I want to say 1863, 1864. Uh, so for a long, long time, if someone who was enslaved in the southern states ran north to find freedom, they could be found and taken back to be enslaved using the Fugitive Slave Act. But there are cases of jury nullification during this time. For example, in 1851, there was a person named William Jerry Henry. His rescuers were acquitted. After forcibly freeing someone who was taken in by the Fugitive Slave Act. He was forcibly freed him from federal marshals. And a jury said, that's fine. Our morals say, or whatever reasons we have, say that that is a reasonable act to take, and we're not convicting someone for that. So there were dozens of cases like that where juries refused to convict. And some states, there was so much jury nullification happening that they actually couldn't enforce the Fugitive Slave Act in those states. So that was before the Civil War and before that act was revoked. The way that people kept each other safe was by using the process of jury nullification. We saw this also during the Civil Rights Movement. It we the civil rights movement is a moment where we saw jury nullification cut both ways, right? So you had folks who were enforcing, like using Jim Crow tactics to intimidate and harass folks who were fighting for civil rights. So we can think of the death of Emmett Till. His murders were not convicted. They nullified that jury. And on the flip side of that, a lot of civil rights leaders were able to continue the fight for their civil rights because juries stepped up and refused to convict them when trumped up charges were brought to them. So we saw examples of this in Albany, Georgia in 1962 and Jackson, Mississippi in 1963. These were moments that jurors refused to convict civil rights demonstrators for disturbing the peace, recognizing that they were enacting their right to free speech and their right to peaceable protest. Um, so there an anti during the Vietnam War, anti-Vietnam War activists also sometimes benefited from sympathetic juries. So in 1972, a Boston jury acquitted Dr. Benjamin Spock and his co-defendants who were accused of counseling draft evasion, though others in the same trial were convicted. So mixed or acquittal verdicts reflected community divisions and moral resistance to the war. I'm not sure what that sound is.
That was someone calling me. Sorry, y'all.
As someone who is like, I want to know more about jury nullification, send me the link. Uh, but yeah, so jury nullification, it can reflect like these kind of mixed moments that we have. And when folks are clear and folks believe that there is something else at play in a jury, we can see these examples of jury nullification even during mixed political moments. So we've seen, as Daniel pointed out, the sandwich guy, but there have been even more examples in the Trump era. The LA protester who was charged for assaulting a Border Patrol agent, a federal jury acquitted him in under an hour, right? We don't need a full hour for this. Charles, the sandwich guy, we just went through his case about how jury nullification worked. And there's also a number of other cases tried by the Trump Department of Justice that have been rejected. We are in a moment in Chicago. So I live in Chicago, and there's been a lot of resistance to a lot of the overreach from the federal administration in our neighborhoods and communities. And we're just now starting to see folks face charges, indictments, those kinds of things. And so I anticipate that the role of jury nullification is going to be really important as another way to support folks who are doing the good work and pushing that things like due process, things like due process, things that have been established as like the law of the land get protected even in moments where that's not actually the case. So just as one more moment of, thinking about jury nullification, I want to invite folks to drop in the chat what are other moments that you can see jury nullification being used in these times. Now that we know it's the legal right of jurors. There's a long history of jury nullification in the country. I talked about some examples in Chicago, but wherever you are, what are some ways that you can see jury nullification being used? So nonviolent drug charges, 1,000%, right? Nonviolent drug charges have been a tool that have been used to incarcerate certain communities en masse. And so nullifying, using your right as a juror to nullify can totally be a way to disrupt that. Eviction cases, where landlords violated the rights of tenants, direct action against environmental extraction, Fourth and First Amendment, yeah. Anytime there's a selective prosecution, someone used Latin. I love that. If you want to explain the Latin to me, because I don't know it. But Daniel and I both had a chance to talk to movement lawyers in prepping for this and making sure we were not saying anything untoward. And a lot of these examples that you shared were examples that I heard in my conversation with a movement lawyer, that this is a right that you have if you're picked as a juror. So it's definitely for these cases that we're seeing in this moment of authoritarian rise. And if you're ever a juror on a case, this is a right that you have as a juror, to nullify a jury if you feel like there is a reason to exercise it. And we're gonna just watch a little bit of a video because again, folks walked in, is it legal? We want to be above board. Um, and it is. It is absolutely legal. Jurors cannot legally be punished for their verdicts, no matter their reason. It's your right to return a verdict, and a judge cannot direct a jury to deliver a guilty verdict. They just can't tell you what to do. That's the point of a jury, is that someone can be tried by their peers. So this is, we all in eighth grade civics probably learned about checks and balances. This is one of the ways that a jury can offer a check on our legal system. What it doesn't mean, though, right? Like, even though it is 100% legal, that doesn't mean that prosecutors or judges won't discourage it. They might imply or they might downright lie, right? They might say that's not allowed. Even when they're giving instructions to the jury, they might claim that there's no such thing or that doing jury nullification violates the juror's oath. It doesn't. It just doesn't. So if you don't trust us, because we're Daniel and Latanya, your friendly neighborhood freedom trainers, you can probably trust a Supreme Court justice. Supreme Court Justice Sonia Sotomayor got asked this question and had like a really lovely response. So we're just going to watch that for a moment.
I finished an article yesterday that Professor Charles Wolfram wrote in 1972 on the history of the Seventh Amendment that said the people who were responsible for insisting that the Seventh Amendment be part of the Bill of Rights, and by the way, he attributes the whole existence of the Bill of Rights to the concern with jury trials. And they
Oh, can we turn it up?
They didn't put it in the original Constitution. It was promised as a quid pro quo for ratification that we will have a Bill of Rights that guarantees civil jury trials. That those people wanted jury trials not because they would get the same result as a judge, but because they would get a different result than the judge. And they wanted it in spite of the fact that jury trials would be longer, more expensive, maybe less predictable. So I had forgotten that. I was really never focused on that as being the reason for, if we just went back to the reason for the Seventh Amendment, that maybe that's the answer to why America.
The Second Circuit has an opinion that basically says that juries should never be instructed about jury nullification, and that any instruction that would suggest it is wrong. I hewed very closely to the Second Circuit line for many, many years. As I've grown more in the system and watching it, I'm not so sure that that's right. Think about what juries did during the civil rights movement. If it weren't for jury nullification, we would have many civil rights individuals who would be convicted felons or otherwise for things that today we think are protected by the First Amendment. There is a place, I think, for jury nullification, finding the balance of that and the role that a judge should or should not play in advising juries about that is, I think, a different thing. But I think that you're right, our forefathers did not believe that juries necessarily always got it right. But it was, I think what they believed is that the jury getting wrong was better than the crown getting it wrong.
Yeah. So I know the volume on that was like a little bit of a whisper. But lawyers tend to talk in grave whispers. That's them. But just to summarize, the idea that Justice Sotomayor was sharing was that juries are a check on judges. Juries are a check on power. Juries are a check on the crown. And there is, of course, the possibility that juries get it wrong. It doesn't mean that they have special knowledge where they're going to get it right 100% of the time, but surprise, humans never do. And our judicial system is stronger if there is the invitation for everyday folks to review the facts of a case and to offer their input, and for that to guide the decisions around justice in this country. And that should happen without the influence of the judge's opinions on the case or any wrong guidance from the lawyers, but that jurors should be able to decide how they want to what they want to do on the case, and that's an important check and part of the process. This video is going to be in the slides, so you can definitely look at it soon, and Daniel is also going to share a link. But I'm going to kick it to Daniel to talk about how do we do jury nullification? We know it's legal. We know it's an important process in our movement work and in all sorts of things. How do we actually do it?
Okay. So I'm going to really address the question of how does an individual go through the process of kind of doing jury nullification? So the first thing is you got to respond to the summons. So you got to be in the system, et cetera. You then got to get picked. Then you have to deliberate with a conscience. You all seem to be fantastic at that. And then the fourth is not getting removed. So the first one is just again, in our system, not everything goes through a jury. And so there's some conversation tracking. Some things in different states and different districts do or do not go into jury trials as an option. But the first thing is you've got to be a U.S. citizen, and you've got to be in the system. They've got to have your address up to date so they can send you a summons, and then you've got to respond, and you've got to respond honestly. And so some different locations offer jury pay. Again, there's variance, but the basic thing is you got to respond. The second piece is getting picked, and that actually is often very difficult for folks who have been thinking in activist ways or movement ways, or folks who have been thinking about jury nullification. And so this process of jury selection is when judges and attorneys, they get to ask you different kinds of questions to see whether or not you can be fair and impartial in their, I shouldn't actually say whether you can be fair and impartial, but whether or not you can be fair and impartial to their perspective, to the perspective that they're wanting to do. So each side gets a chance to ask you different questions. So often there's a form that you'll ask ahead of time that has some very basic questions. Do you know someone who has, will that get in your way of? And so certainly if you say anything up front that says that you will be a biased juror, that is a reason to remove you pretty much right off the bat. So certainly each side gets to remove someone for cause. So if they have an arguable reason why it appears that you will be a biased person. They also have a limited number of preemptory strikes. That is someone that they don't need any reason. They can just remove someone. Some of these, again, differ from place to place, exactly how that works in terms of your state. But the basic process is that. So we're going to just share a quick little slide that kind of says some of those same things, and then we'll dig just a little bit further in.
Did you know that there is an interview process for serving on a jury? Depending on how this interview goes, the attorneys on the case can kick you off the jury for any reason they want. Well, any reason short of discrimination. This interview is conducted on the record, meaning that you are first placed under oath before your interview, and all of your answers are transcribed by the court reporter. This interview is known as voir dire. but you might know it as jury selection. What you might not realize, though, is that picking a jury is more about deselection rather than selection. The sole purpose of voir dire is to determine the suitability of potential jurors to hear a particular case. The ultimate goal is to assemble a jury that can objectively weigh the evidence and render a fair verdict without bias or prejudice. During voir dire, the attorneys are simply trying to determine which jurors need to be kicked off the panel. Jurors can be removed with a challenge for cause or as a result of a peremptory challenge. Challenges for cause are legal motions where the attorney believes that the juror is actually prejudiced against the client or has expressed a bias that would prevent them from being fair and impartial. Peremptory challenges are a tool employed during jury selection that allows attorneys to excuse a potential juror without ever providing a specific reason. Unlike challenges for cause, which require a demonstrated bias or legal disqualification, peremptory challenges are exercised at the discretion of the attorney, provided that they do not violate certain constitutional principles. The number of peremptory challenges varies greatly from trial to trial. Before we go any further, do you actually know how jury selection works? Let's demonstrate with an example. The question everyone has is, what are the chances of me actually getting picked for jury duty? Imagine if you and 19 of your friends stood in line to ride the last Ferris wheel ride of the day. This is a tiny Ferris wheel that only carries 12 people, and when it's full, the carnival closes for the day. You're number 20 in line, so it doesn't seem like you have a very good chance of riding the Ferris wheel, does it? Not so fast. The Ferris wheel operator starts asking all 20 of you questions about your experiences with Ferris wheels. One person in line states that he actually hates Ferris wheels. One person in line states that she has a history of vandalizing Ferris wheels. And then another person in line states that he has debilitating motion sickness. Before the Ferris wheel operator started asking questions, the first 12 people in line would be getting on the ride. But after these answers, these 3 people are kicked out of line for cause. Now, of the people left in line, original numbers 1 through 15 are guaranteed to ride since they are now the first 12 people in line. But wait, now the Ferris wheel operator gets to kick 5 people out of line without having to give any explanation why. The peremptory challenge. He kicks 5 people out of line. That means you are now in the first 12 people in line and you just found yourself on the Ferris wheel. That's exactly how jury selection works. The first 12 jurors who are not kicked off will serve on the jury. As a potential juror, it is essential for you to approach the jury selection process with an understanding of peremptory challenges and the reasons behind their use. Here are some key points to consider. Jurors often have limited information about the case during voir dire. Attorneys may use peremptory challenges based on general impressions, body language, or other subtle cues that may not be apparent to jurors. It is important for you to recognize that these challenges do not necessarily reflect on your character or qualifications. Attorneys may employ peremptory challenges as part of their trial strategy. The selection of a jury is a dynamic process, influenced by the unique aspects of each case. Certain individuals may be excluded not because of any personal inadequacy, but because of how their presence might impact the dynamics of the trial. If you appear to be a natural leader and have given answers that seem like you might be sympathetic to the other side, then the attorney likely wouldn't take a chance by leaving you on the jury, as it's just safer to use a peremptory challenge. It might not be anything that you say or do during jury selection that causes the attorney to use a peremptory challenge to remove you from the jury. Sometimes it is as simple as where you work or your education history. If you work for a government agency, then you could be viewed as sympathetic to the state during a criminal prosecution. If you have a graduate degree in a scientific field, and the case has a medical or scientific aspect, then you could be viewed as someone who might try to apply their own experience rather than applying the admitted evidence. While peremptory challenges are a valuable tool for attorneys, their use is not without limitation. The Supreme Court has established that the exercise of peremptory challenges based on race or gender violates the Equal Protection Clause of the 14th Amendment. These days, such protection would also likely apply to attempts to use peremptory challenges on the basis of race, creed, religion, national origin, or even sexual orientation. If an attorney suspects that the opposing party is using peremptory challenges in a discriminatory manner, they can raise a Batson challenge, prompting the court to evaluate the legitimacy of the challenges. When attorneys ask questions during voir dire, it is essential to answer truthfully and candidly. The goal is to provide a complete and accurate picture of your background, experiences, and potential biases. Honest communication is crucial in forming a jury that can fairly assess the case. Remember, you'll be placed under oath to tell the truth before you even start answering questions. Because of that, it is extremely difficult to avoid a proper peremptory challenge without committing perjury. When you're asked questions about your experience and your answers reveal that you might be biased, well, there's nothing wrong with that. It doesn't mean that you wouldn't make a good juror. It just means that you might not make the best juror for this particular case. At the same time, if you're trying to get out of jury duty, you shouldn't answer untruthfully in an effort to get removed. I've heard people plan to say some pretty outrageous things in order to be excused from jury service. The real secret to getting out of jury duty is to just speak up and answer questions. The less you say, the less reason the attorneys will have to remove you. The more you participate, the more likely the attorneys will uncover some form of bias. The most important thing is for you to have respect for the legal process. One day, you might find yourself in need of a fair and impartial jury.
Okay, so that's one's take, right? And so what are some of the different reasons that if wasn't thinking of jury nullification, why you might not get selected? So one, obviously, if you're admitting bias of any sort, um, so saying that you won't convict someone, saying that you don't trust police, saying that you don't trust the judicial system, etc., saying that you would refuse to convict someone under a particular law, et cetera, et cetera. So certainly any conversation that you would have if you say anything around jury nullification, those are reasons to be perceiving you as having a biased opinion. From there it gets more subtle, and there's a handout that we'll link to that gets into even more some suggested details. But like if you don't follow instructions, again, you can be taken out for cause. So any preemptory challenges are an option. Um, uh, but a lot of it relates to like what they often say is the suggestions are like speak very, very briefly. So don't give long explanatory answers. So uh, do you know of anyone who, for example, a question you might be asked is, do you know anyone who's been accused of breaking a law? And I think the answer could be, yes, I do. Um, and they might ask you a follow-up question. And you say, well, I've been involved in speeding in the past. That's something I could honestly say. And typically they don't ask necessarily if you give very short things, lots of follow-up questions. Is that all of the times you've ever been arrested or so forth? Um, and again, I think a lot of those are related to, questions that might get asked. I'll just give an example. Like, how do you feel that the government's using paid informants um, in order to use paid informants to reduce their sentences in return for their testimony? And bland statements of like, I guess we'd have to, examine the testimony really carefully and figure out, whether it was fair or not. Flattened answers as opposed to long explanatory. So that's some things that can be part of the practicing. So again, the tips for being selected that we're suggesting and that we're kind of hearing the most off from people is just dressing neutrally. So if you have a lot of piercings, if you have a lot of things that you might want to make a conscious choice to moderate your body language and whatever you're bringing in. Consider how you can answer both truthfully and neutrally. So again, different ways of kind of conflating to short answers. Keeping your answers brief. Do not mention jury nullification or any jury education that you've received. It's not necessary to add. Don't seem too eager to be on a jury. People typically, that's a warning sign for a lot of people. And then just emphasize that you can't commit to a particular outcome before you've actually seen the case and so forth. Once you're on the jury, so let's assume you're on the jury, then it's about deliberating with conscience. And so as a jury, you get to make a legal challenge, a legal determination. And so you can only use the information that's presented at trial. So you don't get to bring other information that you kind of know about the specifics of the law. They will explain that part, but you do get to bring your conscience. And so you get to decide what testimony you believe, how confident you are. You get to decide what you say to other jurors about whether or not you're fully confident or not. You could attempt to persuade a jury to try to join you in also saying they're not guilty for whatever reason. And again, you can't be punished for your decision. Once you're in that jury room, you are the judge. And so you always have the option in that sense of finding someone not guilty. Again, there are moments where you can see judges putting pressure on you and digging in on that. But a judge can't make you convict. So again, you have lots of reasons you could say not guilty, kind of just explaining many of the things that you've already identified of your conscience says I wasn't convinced. the law itself is unconstitutional. There are other factors. You just aren't persuaded. Just to really emphasize the point, like there's no partial credit for prosecution. So if you're not 100%, if it's 99.9%, that's more than enough for you to say that I'm just not fully convinced. And so in the jury room, that can be a source of challenge. So there's stories from folks who've been on jury rooms for 6 weeks as they were a holdout in a jury where everyone else was convinced the person was guilty. And this one person said, I'm not convinced of it. And so they made a decision, tried to go back to the judge. The judge said, no, take more time. So they spent weeks and weeks and weeks. And people were very angry and frustrated with them in that room. And so that's a thing that can get faced. And they held strong, and they later found out the person would have been put in jail for 25 years. And so 6 weeks of some amount of suffering in lieu of someone who would be wrongly imprisoned for 25 years felt right and appropriate. The last thing is you can get removed. There are conditions under which you can get removed by a judge. And so it's typically it would be for cause is the legal explanation. There's a number of different things that could be during it. So there's things like uh, you could be discussing your intentions to do jury nullification. There's no reason for you to say, I'm involved in jury nullification. You can say, I am not persuaded that. So articulating it under a framework that says, I'm intending here to nullify would be a potential for cause that the judge could make the argument in the case for. Um, Misconduct or other kinds of grounds for removal can be I'm trying to tell other people to do jury nullification, or I've been trained by, or that kind of behavior. So again, we're not actually suggesting this is the language that one would want to use through inside the jury pool, inside the jurors room. Instead, it's more about your conscience, and so weighing those. Um, During deliberations, it is fairly rare for judges to remove people, but they can if they can make the argument again on cause that the juror itself, the juror's not following the law. And so again, discussing jury nullification as such might be a grounds for dismissal. Discussing it in the form of I'm not persuaded that this person doesn't seem to have done actually significant harm. And so them getting prosecuted, I'm not persuaded. That is an appropriate thing, but simply saying I'm nullifying this whole thing would be a challenge for a judge might throw you out, would be very likely to throw you out. So again, you can simply say not guilty, and you do not have to actually explain your rationale or your reasoning, and no one can force you to convict or overturn your decision. Last thing, so then what? So after the case is over, we just want to mention after the case is over, we don't recommend, it's not suggested to actually go out in public say I did jury nullification. So certainly never discuss it before. That's again another reason for being kicked out of a case if you're seen as giving information about a confidential proceeding. But even afterwards, you could give ammunition for a future prosecution if they could make the argument that the jury was, in one way or another, an illegitimate jury or so forth. If you're not sure, you can talk with a lawyer. There's certainly conditions in which people have talked about jury nullification after the fact, stripping out some of the extenuating details, or choosing to make that public for particular reasons. Um, and then just to add, knowing that you have added a little more justice into a very unjust system. So it's very difficult, not impossible, but it's difficult, more difficult for someone to be retried on the same charge when they're actually been acquitted. So if the jury actually makes a decision to say you're not guilty, if it's a hung jury, the government may try to retry the case. That's often more challenging. That becomes a different kind of political decision related to all those different pieces. So that's the kind of the arc. Again, we do have handouts on all of these different pieces that say a little bit more on kind of all the different steps. Um, but what if you want to spread the good word, Latanya? What if you want to tell other people about it?
Do that. Please do that. And there are a couple ways that you can do that. So, like Daniel shared earlier, we're going to share these slides and just kind of similar to the way that maybe a lot of us have been doing Know Your Rights training, just helping folks understand what their rights are if they're pulled on a jury case is like going to be really important and useful. Also, you are legally allowed to pass out flyers near a courthouse. So if you wanted to pass out information around jury nullification, you can go to a courthouse. The best time would be early Monday morning because that's before the time that people are placed on juries. Um, you wouldn't want to talk about a particular case, right? Because that could be considered jury tampering. You wouldn't want to go and say, hey, the sandwich guy is getting tried soon and they're picking the jury. So if you get picked for sandwich guy, know about jury nullification. You just want to say, broadly speaking, jury nullification is a right you have as a juror. Here's some information about it. Use that information wisely. Um, there have been attempts to folks have been arrested for handing out flyers about jury nullification near courthouses. Those cases, that case and others like it were dismissed because courts found it legal to actually educate the public who about jury nullification. What we can say though is that if you are passing out flyers near a courthouse and someone from the prosecutor's team notices that that's happening, they can ask jurors, have you received literature this morning or recently, or have you received literature about jury nullification and use that to dismiss? So that's definitely a danger of flyering, but it still can be a good idea depending on your particular context and what you know about your community. Another note that I will add, whoops, not yet, is that jury nullification. So juries are, as Daniel said earlier, what you tend to see in a criminal case, right? Like when you're watching Law and Order, that's a criminal trial, and there's a jury there. In a civil trial, the process is a little different. The judge has a lot more leeway. So in a criminal trial, a judge might say, why don't you go back and deliberate more? Um, in a civil trial, if the jury wouldn't say not guilty, they would say not liable. But if the jury says not liable against the judge's sense of the evidence, the judge can actually issue a judgment notwithstanding the verdict, or they can order an entirely new trial, right? So they have a lot more leeway than in criminal trials. Um, Also, some details of juries are different from place to place, such as how much folks might get paid or what the size of the jury are. This is particularly true for grand juries, and also whether verdicts must be unanimous or not. So, as you're bringing this information back to your communities, you definitely want to spend a little time getting clear on what does a jury look like in your community? What's the process that's specific to your context? And what does that mean for jury nullification training and information? So,
If
you've
I can
heard
just
of,
add to Tanya,
yeah, go
one thing
ahead.
that just to emphasize is that I think we're in a moment in which people are going to experiment with some different ways of trying to also try to educate people around jury nullification. And so like just some of the conversations that are even happening on the thread are around whether or not there's mailings. Some of us have been having conversations about there are governors who have come out and favor of uses of jury nullification in particular situations and cases, and so emphasizing those. There's many different like techniques right now I think that are available to us that so we're not trying to be suggestive this is just the only one, but actually there's a range. We're just trying to encourage people to spread the good word and think of the different ways that you want to spread the good word.
Right. I think like a good example from this training is the Fugitive Slave Act. There was a point where certain states were just notoriously, we nullify here, right? Like if you try to enforce this immoral law, we're going to nullify. So that is the scale we are hoping to get to with some of this. Um, Matt, if you have a question, you can drop it in the chat, or do you want to come on? We are going to questions and answers. So Matt, do you want to kick us off with questions? Oh, okay. I see a raised hand and I'm like, oh, lean in. But yeah, what questions do you have? We've been talking, we've been sharing information, but what questions have come up for you? I know there were questions in the chat throughout. I think a lot of them got addressed, but if you had one that we haven't gotten to, feel free to come off mute or drop it in the chat again, and we'll do our best. We also have a signal thread with some movement lawyers that we can drop questions into as well. Yeah, Jackie.